All right, case number 22191. It's right there. 22195-463. Trust Property Management versus Charmaine Alvis. I have this set up for a motion hearing, it seems. Your appearance for Trust Property Management.
Good morning, Your Honor. Hamdi Sob on behalf of Trust Property Management, PA 2080.
All right, thank you, Counsel. Good morning to you, sir. Do I have Charmaine Alvis on the Zoom? If you're here, say something at this time, please.
Yes, Your Honor, present.
All right, thank you, Ms. Alvis. Good morning to you. I see a motion that was filed, something about Sierra holding back money. That motion was denied on the 19th of October. And it looks like to me that this action is an action that somehow sounds in some claim that has to do with a past due rent or something. Counsel, tell me what this is about, sir.
This is an action regarding past due rent. We're pursuing a collection on the remaining amount on the ledger minus the escrowed Sierra funds. So that total would be $1,299.80. And on the ledger is past due rent, and I don't see anything other than that.
All right, so there were some, I take it that there were some Sierra funds that were distributed in regard to landlord-tenant action. Is that correct?
That's correct. Approximately $699.20.
Okay. And that was that amount still left what you're indicating as the balance area, correct?
Yeah, that's correct, Your Honor.
All right. So, Ms. Alvis, I know that when you filed the motion, you indicated that Sierra was holding back money. When there's a claim against you that results from a claim of a breach of contract, then Sierra is not a part of the civil action. If there is something left in the landlord-tenant case, wherein there was some promise that Sierra made to pay something in the landlord-tenant case, you can still pursue that. But this is a separate action to collect upon something that is allegedly owed now. Talk to me about that.
Yes, Your Honor, I understand that at this time. Before I spoke to an attorney, I wasn't aware of that, but I understand. I'm clear about that now. However, there is an issue with the paperwork. The plaintiff served me with a complaint stating that I breached the contract, but there was nothing attached to the complaint. So I was confused about what contract I breached and where that $1,299, that amount came from. So I would like for you to have them put in writing so I can better understand what I'm being sued for, what contract exactly I breached and where that amount came from and how they figure I owe it.
For the record, Your Honor, would be happy to provide that to her. I can email her that right now.
All right. So have you guys had a chance to talk about this, to try to go through what the particulars might be?
I have not.
Why don't you take a moment? Why don't you take a moment to do that? Because you're raising, of course, two issues. If you had a landlord-tenant type relationship, that relationship is either a written contract or a contract by operation of law. In other words, if you were in a relationship as a tenant in a landlord-tenant type situation, that's a contractual relationship. The second part of it that you raise is that the amount may not be accurate. So I'm going to put you in a breakout room so the two of you can talk about that for a moment to see if you can bridge the difference, because it seems to me that the most significant issue here may very well be the issue of what the amount is. And if you can talk about that and see if you can arrive at an amount that seems to make sense to both parties, maybe get this resolved. Go ahead and I'm sending you a notification now to breakout room number 1, and that should be coming up on your device, and you have an opportunity to talk about this matter.
Okay.
All right, there we go. All right, so you should have the notice. Go ahead and click in, and I'll be here on the other side of that. Here. All right, the court is calling now case number 21-153-543. This is Integrated MRI Center LLC versus City of Detroit. The matter is for the court. Looks like I've got this set on. Well, I don't see it on my diary. In any event, your appearance for the plaintiff regarding this matter? Integrated versus City of Detroit. All right, I'll come back to that matter. I don't see anybody responding on that. All right, the court now calls case number 22-189-895. This is Debt Holding LLC versus Martinique Allen. The matter is before the court on the filing of a motion in this matter. That motion is to strike answer and for entry of a default judgment in this matter. Your appearance for the plaintiff in this matter, please.
Yes, Martinique Allen.
Are you representing Debt Holding LLC?
Oh, no, sorry.
All right, I'm looking for counsel for Debt Holding LLC. If you're on the Zoom, please say something at this time. All right, and I take it that Ms. Martinique Allen, you are on the Zoom at this time, is that correct?
Yes,
All right. Okay, I see now that the attorney that's in the breakout room, he has this matter as well. So when he comes out of the breakout room on the other case, I'll get back to this matter at that time.
okay.
All right. This is case number 22-191-224. This is State Farm Fire and Casualty Company versus JJ House Company LLC. The matter is before the court, set on for a hearing on today's date. I believe that the court established this as a scheduling or status conference date. Your appearance at this time, counsel?
For the record, Your Honor, Albert Kim, P70301, appearing on behalf of plaintiff in this matter.
Good morning, Your Honor. Ryan Justimer on behalf
Counsel,
of Jay.
to you for JJ's House Company LLC. I'm sorry, go ahead. Your appearance at this time, counsel.
Thank you, Your Honor. Ryan Justimer on behalf of JJ House's Company.
All right, your P number, if you will, for the record.
P63065.
All right, thank you, counsel. Good morning to you as well. I see the answer and affirmative defenses and what have you in regard to this matter. And I don't see my order setting this up for a, yeah, I see it here for a status conference on today's date. All right, so somebody update me regarding this matter. Look like this is a claim for some $18,514.38. Have you talked about this at all? Somebody tell me where you are in regard to this matter.
Your Honor, again, this is actually a collection matter based off of some workers' comp and general liability insurance premiums. I show my balance at 5,000, I thought 5,000 and change. That being said, we have conducted some preliminary and voluntary discovery amongst one another. Opposing counsel has provided with me some extra documentation that may affect or may actually cause a revised audit. That documentation was submitted to my client last Friday or Thursday. I can't remember exactly, but last week. Obviously, we're dealing with State Farm, so they're a larger entity, so there might be a little bit of a turnaround time as to the revision, but there's likely going to be some sort of revision based on what I've seen in my experience with these files. We may be able to get this resolved based on that revision. So I don't know what the court would want to do, maybe set some dates, but at this point, I think we just need a little bit of time, and I think this case may resolve itself if opposing counsel agrees.
I agree with brother counsel.
All right, makes sense to me. Two lawyers that have managed to work this out without putting a schedule on it. So at least in terms of the direction things should take. So why don't I set it over for? I'm thinking late December because that's I'm being optimistic. So I was thinking that maybe we put it on the say the 22nd of December.
That's fine, Your Honor, for me.
That makes sense. All right.
Yes.
All right. So I'll go ahead and stick it there. They give you almost, to the end of the year to kind of get it here and at least give me an update on what's going on. So if that's okay with you, council, as well.
Yes, it is.
Okay, all right, so I'll go ahead and set it for the 22nd of December, and I'm gonna set this for 9:45 a.m., December 22nd, 9:45 a.m. And I'm setting the matter over for a review at that time. So we're continuing the pretrial, and I'm adding to that is up for review. And then we'll take some time to see where the case is at that time. That'll put us in a better perspective as to what to do next if it has not been resolved. All right. So December the 22nd, that again is going to be at 9:45 a.m. All right. I wish you well, gentlemen. Thank you very much, and good day to you.
Thank you, Your Honor.
All right, this is case number 21-165-479. This is Michigan School and Government Credit Union versus Gordon Camp. The matter is before the court on the filing of a motion. It looks like I see a motion to stay execution of a judgment that was previously entered in this matter. That judgment was entered by default on the 14th of June of 2022. The total amount of that judgment was at entry is $15,109.53. Your appearance for Michigan School and Government Credit.
Yes, good morning, Your Honor. Stephen DeLuca on behalf of the plaintiff, my P number is P70009.
Thank you, Counsel. Good morning to you, sir. I'm looking now to Gordon Camp, counsel for Gordon Camp or Mr. Camp, your appearance at this time.
Eric Holmes, on behalf of Gordon Camp, P83435.
Thank you, Mr. Holmes. Good morning to you, counsel. All right, I see that there's not a motion to set the judgment aside, but a motion that seems to stay execution. Tell me about that, if you will.
We've been able to talk and discuss. We were in the breakout room and we agreed to kind of adjourn this. We're coming close to a number on the settlement. So we were hoping that we could just kind of put this off. I think we can come to an agreement.
That makes sense to you, Mr. DeLuca?
That's correct, Your Honor. I think we're closer and there's a decent chance we'll be able to resolve this.
So in the last case, I set it over like to the end of the line, at least for this year, just to keep everything in 2022. And so I'm giving that December 22nd date. That makes sense to you, Tim?
That's fine with me.
December 22nd, that's fine.
So I'm going to go ahead and set it for 10 o'clock on that date, 12/22, 10 o'clock a.m. And I'll set the matter over for review and we'll see where things are. And if we have to deal with some other issues, I'll take those up at that time. So 12/22 at 10 o'clock a.m.
Okay, thanks a lot.
Okay, thank you, Your Honor.
Have a good day.
Good day to the two of you.
All right, have a good one.
And Ms. Allen, we're waiting for the gentleman to come back as he is representing his client in the case. He's in the breakout room and he's the attorney on this case as well. So as soon as he's back in the court, we'll deal with that one and I'll come to your matter at that time.
Okay.
Your Honor, any orders, can you send them to my email?
Yeah.
They have place to print it. Then I'll print them out.
Okay, good. So we're still down.
Yes.
Largest ticket.
So you're not gonna do an order, I'm just gonna do the NTA and put that in?
Yeah, you just, right.
Gotcha.
You just notice of hearing the tab in there, so. Impression. All right, we're back on the record regarding trust property management versus Shemaine Alvis. The suffix is 5436, excuse me, 5436. Thank you to both of you for taking the time to go out and talk about this matter a bit. And Council, you've already ended your appearance, and Ms. Alvis has indicated her preference as well. All right, Council, update me on things regarding this matter. Sir.
Your Honor, there's an obvious dispute on what's owed, as indicated prior to going into the breakout room. And I spoke to Ms. Alvis and I made her aware that so Ms. Alvis has made me aware that there was a credit that was supposed to be issued out to her for some of the amount that's due. And it was never issued out to her, is what she's claiming. I don't have that information at hand. I have to confirm with my client whether or not a credit was actually supposed to be made out to her for one of the months that was owing with respect to this suit. And then the other month, so it's a total of 2 months that's owing. The other month that's owing, Ms. Alvis has made me aware that she has attempted to place into escrow with the 36th district, but they told her that she could not place it into escrow. And the reason she was placing it into escrow was because a C of O issue. Again, Your Honor, I was never told this beforehand by my client. They told me these are the months that's due. I think a brief conversation with my client would be able to clear up some of the issues and possibly reduce the amount that's owed. I can't speak to that now, but I have Ms. Alvis's email address and I sent her both the lease and the ledger that I have. But I'd be able to clear it up with further conversation with my client.
Ms. Alvis, that makes sense to you. I think what I'll do is set this out to bring it back and you guys see if you can get it worked out and maybe some traction here. And then come back, and if you haven't been able to work it out, we'll figure out what to do from there. That makes sense to you, Ms. Alvis, at this point?
Yes, sir.
And so why don't I could do it, if you wanted to keep it in this month, you thought it would be fruitful to do that, I could bring you back on the 23rd of November.
That's fine with me.
All right. That works okay for you, Ms. Alvis?
That's fine, Your Honor.
So I'll go ahead and adjourn it over finding good cause until November the 3rd. Now I'll go ahead and set it at 10 o'clock a.m. And by that time, the party should be able to see where you are in terms of the discussion that you had today. And then we'll go from there. That's going to be the 23rd of November. And that's going to be at 10 o'clock p.m. Right. And you'll get another notice in the mail, but go ahead and note that date, November 23rd at 10 o'clock a.m.
Thank you, Your Honor.
Right.
Thank you.
Just one moment. All right, this is case number 22-189-895. This is Debt Holdings LLC versus Martinique Allen. The matter is before the court on the filing of a motion for summary disposition, a motion to strike answer and enter default, and the alternative for summary disposition. This Martinique Allen is on this Zoom, and I didn't realize that counsel on another case was on this matter, so I called it earlier, and then I said I would just hold it over until counsel got out of the breakout room. Your appearance for Debt Holdings LLC, sir.
Good morning again, Your Honor. Hamzi Sob on behalf of Debt Holdings PA 2080.
All right, and thank you again, sir. And Ms. Allen, you've indicated your presence here as well. I did see where you filed an answer in regard to the case that was filed against you. And it looks like the claim in this matter is for $17,193.28. Have you received a copy of the plaintiff motion that was filed to strike the answer for default and or for the entry of a motion, the granting of a motion for summary disposition? Did you get a copy of that motion, ma'am? Ms. Allen, are you able to hear me?
Oh, no, I never received the copy of the motion of strike.
So I set this for a hearing today. So you received the notice from the court, is that correct? You
Yes,
saw a
I
notice
received,
telling you-
yes, I received notice from the court.
Okay, and you didn't receive it, you're saying you didn't receive any other paperwork regarding what this hearing was about?
No, the only thing that I received was the summons that is not even my summons. It's a Michelle Flicksher at 2916 Glendale, apartment 2. And her lease, that's the only thing that I received when I was served.
All right. So do you live on Brush Street in Detroit?
Yes, 9843 Brush Street, Detroit, Michigan, 48202.
Okay. I don't want to pull all that out there because we're on.
Oh, I'm
YouTube.
sorry.
That's why I asked you just about this. Okay. All right, counsel.
Your Honor, if I may, I personally mailed the motion to the Brush Street address. And I'm looking at the filed summons and complaint with the court, and it lists Mrs. Allen's name as, and then followed by the complaint, which also has Mrs. Allen's name as the case caption. The addresses on both of those match, and then the motion, the only reason I'm saying this is because every motion I've ever drafted, I send myself just to confirm that it's actually been sent, and I know that I sent it personally to Miss. I put it in an envelope. I hand wrote the envelope like I do with all my mailings. But Your Honor, just to give her the opportunity to defend herself, I'd be more than happy to set this for a different time so that she can answer our motion and have an opportunity to view it.
Certainly the extent to which Ms. Allen says she has not received the document, I'll reset it so that can be addressed. Here is the rub in this is that counsel through their motion are basically arguing that the answer does not address the underlying issue in this case. And basically this looks like a complaint that has attached to it a diary of things alleging that that there were various rent charges, water charges, also a diary of various payments made over time, and an indication of several missed payments that resulted in ultimately the judgment amounts or the amounts that are being requested. All of this too seems to relate back to as far back as 2013 and as far up as 2022. So the allegation here is that you were living in a property and over a significant period of time that there were rental charges and charges that were not paid, and that's how the amount accrued to the sum that is now being requested. So a primary question here is did you in fact reside somewhere that this complaint is about somewhere?
No, I never lived there. I ran my hair salon business out of there. And
it was a commercial type situation. Okay. So I think we crossed over talking to each other, but I see it now, you were in some type of commercial lease where you rented some property or you rented some property at East 7 Mile in the city of Detroit, correct, ma'am?
Yes.
All right, so council, at least on parts of this, I'm looking at some claims relating all the way back to 2013. Why is this a claim that seems to sound in a breach of lease breach of a contract? Why is the suit for damages relating to 2013 just now being brought in 2022?
Your Honor, I'm seeing what's being brought is the most recent charges of non-payment. From I believe it was 2018 and on forward. Actually, sorry, from 2019 and on forward.
Okay, all right, so because what's attached to the complaint, I guess it's a complete diary of the relationship because it goes back to 13 and the documents that I have come all the way up to 5/11/22. So you're saying that while you have a complete or something of a complete diary of transactions, that only part of those transactions are whether being sued for more recent stuff. Right?
That's correct, Your Honor. We just didn't want to provide the court with an incomplete ledger or diary. But Your Honor, what I'm seeing is from the first date is on April 30th of 2016. Is it different on
Well, the sheet that I have, it has a terminology you use active start, and then it has active end. Active start is 3/20/13. It has active end as 5/8/18. But then the documents which goes through page 5. On page 5, it deals with, it comes all the way up to 5/11/22.
Yeah, I believe that's the interest rate that's collecting. But so I would say that the time periods in question would be from 2017 to 2019. That's the breach era, and then past those dates would be any interest rate and any transferred debt, because the seven Investments LLC is a subsidiary of Debt Holdings LLC.
All right, got it. So obviously, one of the concerns the court raised, not to raise any defense as such, but obviously, if we're talking about some issues related to 2013, those are likely the challenges that would be time barred unless they've been sued on before. That's what I was getting at there.
Completely understood, Your Honor. And we would not raise any claims on any issues from 2013 or within or past the 6-month statutory time period.
All right, got it. So I'll go ahead and adjourn it. I guess the question here is that what is your dispute regarding this? It seems that you did, in fact, Ms. Allen, that you did in fact lease some property for the conducting of your business. What are you disputing about this in terms of the suit that's brought against you?
I'm disputing that the time limit and also me breaching the contract. I did not believe, I'm sorry. I did not breach the contract at all because within the past 3 years, money was placed into escrow because it was a lot of problems that was going on with the building, and from roofing problems, from leaking problems. So all of that had turned into me have to force and close my business and move out, because all the time that I did have stand there, it was like always a problem and something was always going to be done about it, but nothing was never done. And I can't conduct a business in those type of conditions of the building. So I had to leave.
All right. So oftentimes of course, in a residential lease, where you're talking about where a person lives in a house or property, et cetera, then there are certain requirements under law that have to be met because it's residential. Oftentimes, when there is a commercial situation, the parties usually have an agreement that the person occupying the premises is responsible for the maintenance and upkeep. Was your agreement something different than that in this commercial lease?
Yes, mine was just the maintenance of the inside of the building. So like the furnace, the water tank, and anything that, not the roof, not the walls. So the four surrounding walls. And the main problem that I was having was with the roofing. The roofing was caving in, it was leaking real bad. So it's nothing that I could do. And I'm not going to fix it's a 12-unit building for a roof.
All right, so you said that money was put in escrow. Is there yet money in escrow? What happened regarding
No,
escrow?
it was released back to me. It was put in escrow several times. So it was several times that I had to come to court for the same matter and stuff
Yeah.
of holding
Well, let me stop.
rent
Let me
because
stop. Let me stop you now. You answered my question. So there's not an escrow existing at this time. That was my question.
no.
All right, and so you're saying that when this matter was litigated in another setting, that there were times when escrow was required, and then ultimately the court ordered a release of that escrow in some fashion, correct?
Yes.
All right, so counsel, what do you know of the merits or lack of merits or anything regarding a infrastructural issue like the roof interfering with the ability to operate the business, sir?
The only thing that I know is if something would have happened where there was a structural issue with regards to the roof or any water being leaked into the property, the landlord would have definitely fixed it themselves, or B, go through an insurance claim and have the insurance cover it for repairs. So a repair would have been done, and would have been done immediately. Again, Your Honor, this is non-payment spanning almost 2 years. So with respect to a leaky roof, Miss Allen, with all due respect, would have to say effectively that there was a leaky roof for 2 years, which I don't think that's the issue, because then you would have to say you waive that you waive that condition, that conditional issue. But again, Your Honor, I was told that any repairs were done, any issues of repairs when noticed were done within the month.
All right, so what was the monthly rental rate on the unit?
The monthly rate
$750.
was
All right,
$750.
okay, $750. So, to get this, obligation to $17,000 is what the claim is here. Were there some other obligations that were associated with that? Did you have some other payment that you had to do with rent? You paid rent, and were you required to pay something else, utilities or anything like that?
It was the water, which the water was turned on illegally. So it was the water that I was being charged for too.
How much would you typically pay as a water bill?
$50.
$50. All right, so let me just, one moment. So basically, that you guys, I guess you're about at the same uh, uh, I guess, what it sounds like this claim involves something like maybe 21 months or so that there is a claim. So so you signed did you sign a 6-year lease or something, or was it, what was it?
No, it was a 1-year lease.
Was it automatically renewable or something?
Yeah.
I thought I saw something.
The lease was, the commencement date was in November 1st, 2016, and then the expiration of the initial term would be October 31st of 2018. And then there would be an optional 1-year extension.
All right, got it. I see it. So when is the last time that you operated at that location, Ms. Allen?
It had to be, hold on 1 second.
But it had been sometime in
The
2018.
last time of me operating in the building was it had to be December 15th, 2017.
So, and then that date stands out to you for some reason. Did you surrender the premises at that time, or what happened? How did you end the relationship?
I surrendered the premises, and also I sent out emails for them to come and fix the units and stuff, and I was told that someone would be out there, but February 23rd is when they actually contact me back, and nothing was still done. So it was December 15th was the last time, but I was still there until March the 25th, I think it was. 2018. But I was not operating in the building, waiting for them to fix the situation, the roof and the leakiness of the roof. And I also sent in pictures and everything to the courts too.
So it seems to me that there was some litigation that was before this in some underlying issue. But what did the court do in the underlying case? Did the court grant some type of judgment, some type of relief? Counselor, if you know, update me on what happened in that litigation.
I don't know what happened in the landlord tenant matter. This file was given to me just strictly for the collection side of it.
Got it. So to the best of your knowledge, Ms. Allen, what happened in the underlying litigation? Did you get a judgment or order or something from the court?
No, on my judgment, I sent in to you guys too. To the court, I'm sorry, to the court. It was zero judgment that I owed. So the judge that I had before actually had the attorney write it down. What was the judge name?
All right. So when you the judgment that you had, it's it terminates the relationship. Is that correct?
Yes.
All right. It's not a judgment that deals with a calculation of money or anything. It's just an order that terminates the relationship. Correct?
Correct.
So yeah, that's what I was getting at, is whether or not a judge had made a determination. Sometimes what happens is when the parties, when the relationship ends, there's a determination of money that's owed. This sounds like a judge reached a determination of the rights of the parties, that the plaintiff had the right to take back possession of the property, of the parties go their separate ways, and now there's a suit for money. Sometimes there's a suit for money based upon a money judgment, or excuse me, based upon a judgment that was entered with a certain dollar amount, and that's what I was getting at, to see if that was it. All right, so what I've been, the reason I've been asking the questions that I've been asking is to try and figure out if there was room here for the parties to try and reach some resolution. I will go ahead and set it up for the motion hearing, and then that motion, a copy of which will be sent out to you again, as council believes he sent it before, to the Brush address. And then you'll want to either respond to that so that the court can address this motion the next time that you hear it. It does sound to me that the parties need to maybe talk about this a bit, because, you know, it's a commercial situation, so it makes it a little bit more difficult. But if in fact there were some, if in fact there were some material interferences with the ability to operate the business, then that could mean that some of the accrued amounts would need to be compromised. And I know that we're talking about a big number, because we're talking $70,000. And so even if you cut that in half, you're still at, you know, you're still at 8,500 or so. But it seems to me that there is probably something involved here that should result in the parties being able to trim out some of the amounts after talking about it. But I don't know if you're prepared to do that at this point. So let me just set it up for the motion hearing. We've already got some traction in talking about it. I have a better understanding of the file. And the next time you hear, I'll address the motion. And then if you want to talk about it at that time, ways that you might be able to reach some resolution that makes sense, and you can certainly do that at that time as well. So I'm going to go ahead and set it up for hearing on the 6th of December, December 6th. And that's going to be at 10 o'clock a.m., December 6th, 10 o'clock a.m. And that'll be set on for a motion hearing on that date, December the 6th, 2022 at 10 o'clock a.m. You will get another notice in the mail, and make sure you're in the Zoom on that date. So yeah, you just zoom back in here. What's happening? The reason that I'm talking in the background here is because my courtroom has changed, and they haven't given me the signal to give you the new Zoom number yet. But just come back into this Zoom on the 7th of December, and then we'll figure out from there. December 6th, I'm sorry, December 6th, 10 o'clock a.m.
Thank you, Your Honor.
All right, good day to the children.
You as well. Thank you, Your Honor.
All right. All right. I see that there is someone else on my Zoom, and tell me who you are. Tell me why you're here. I see that you're on mute there. If you will push *6, that'll get you off. Good morning to you, sir.
Good morning. How are you, sir?
I'm good. I'm good. What type of case are you here on?
I'm here for I had a ticket, driving ticket, but I'm not sure if I'm in the right room.
Yeah, you're in the wrong courtroom. All I handle is civil money stuff. So let me find out where you're supposed to be. Yeah, give me your case number. You got your case number with you?
I don't have it. I'm at work right now, and I had a phone notification I had saved.
Okay.
That I had court today. So.
All right. Let's see if we find out where you're supposed to be. So your name is Daniel O'Shea.
Bawachi Yadam.
No.
Bawachi Yadam.
Don't make it
Yes,
hard.
sir.
You say Bawachi Yadam.
Bawachi Yadam.
Bawachi Yadam. Got you. My son's name is Daniel, but we ain't got no Boyaki, Water, but, maybe I'm getting close. All right. So that last name is.
Got it.
Yeah, I'm trying to get her to type it in so we can find out what you're
I
supposed to
have.
be. You got it? Okay.
Yeah, he's for a pre-hearing courtroom 218.
So you're supposed to be in courtroom 218, so you're gonna want to dial, just like you came in here, but you want to put in, the middle number should be 318, correct? 218. 218. So, 218 is, you should be at, what you dialed into is my courtroom, that's 336. So the middle number that you have there, that's 218. So 360, 218, then 0000.
Okay, thank you.
Okay, all right, let them know you were in Judge
Got it.
Coleman's court. If they're wondering why you're late, just tell them you were in Judge Coleman's courtroom and you were in the wrong place, and I can vouch for you that you were here, okay?
Thank you.
All right, good day to you, sir.
You too.
All right, integrated MRI center. That's the suffix 3543. I'm looking at the register of action here to see what exactly is going on. That one, just one moment. I don't know why this one's up. See anything. Oh, yeah, that's 21, 1, 5, 3, 5.
21, 1, 5, 3, 5. Oh, 3, 5.
1, 5, 3, 5, 4.
Yeah, this is set for December 14th.
All right, very well. So, yeah, that's today, right?
No,
that's-
It's November 14th. Slow down, okay? We almost through this year.
All right, yeah, this is, Madam Reporter, this is set for, and I see it on the file now, it's set for December 14th, 2022 at 9:30
Oh, they
a.m.
had stuff in
So,
the stack, yeah.
there's
So
no
we
hearing on
finished.
that today.
A whole month early.
Yeah, we're a whole month early.
Mm-hmm.
Trying to get everything
Trying to get
done.
it out.
So Judge,